My distinguished colleague, Shri Justice Bhushan Gawai, Honorable Acting Chief Justice of the Bombay High Court, Shri Justice Sanjay Gangapurwala, as you refer to him, the most popular judge of the Bombay High Court, who is the Acting Chief Justice. Distinguished judges of the Bombay High Court who have so graciously given up their Saturday afternoon to be with us. Shri Anil Singh, the Additional Solicitor General of India, Dr. Birendra Saraf, Advocate General, Shri Devidas Pangam, Advocate General of Goa, Shri Manan Kumar Mishra ji, Chairman Bar Council of India, Shri Milind Tobde, Chairman Bar Council of Maharashtra and Goa, Mr. Vivekanand Ghadge, Vice Chairperson, Shri Jayant Jaibhave, Member of the Bar Council of India, all the members of the Bar Council of Maharashtra and Goa were so graciously present here, former judges of the Bombay High Court, senior advocates, and all my friends here. When I was a young lawyer, I began with virtually very little knowledge of the practice or procedure of law. I came to Mumbai after a PhD degree at Harvard, but realized how little I knew about the procedure of the courts. But I soon realized that the law is so vast and there was so much to learn that I really scarcely knew the tip of the iceberg. So when I had some very difficult problem, I would go home and I would ask my father, who was a very learned person, that this is the problem which I have been thinking of. The purpose of that was not to tell you what my father would tell me, but as soon as I entered the house, my mother would pull out something sweet, usually a besnacha laddu or something which was made in the house, and stick it into my hand. And both my father, I would get very irritated that, here I am trying to discuss something very serious, and here is my mother sticking this little bowl of sweet in my hand to eat. And if I got irritated or my father got irritated, she would say, "Oh, Aikao, you won't understand this. You won't understand this feeling of love and affection." Now, those days are gone for me because both my parents are very happily residing in a world which is beyond us. But coming amidst you this evening and coming in your midst this evening came as close as I could to the kind of affection which I received. That undiluted affection of a mother handing over something as simple as a besnacha laddu in the hands of a child, albeit who was 30 or 35 years old at the time. So it's really unique to be acknowledged, to be recognized, to be felicitated by your own friends, by your own colleagues, by your own peers. When I was appointed as the Chief Justice of the Allahabad High Court, one of the former Chief Justices of the Allahabad High Court, who was also a very senior colleague and a dear friend, put me on notice. He said, when you become a Chief Justice, your car is drawn by a horse-drawn buggy for the purpose of swearing in. They attach your car to a horse-drawn buggy and then you are led from your residence to the High Court, which is just about a 2-minute drive. But he told me, be very careful about this. They will praise you, they will lift you to the skies on your first day. But then he said, ती लगाम जी आहे ना, तीच लगाम तुला वापरतील मारायला त्याच्यानंतर 6 महिन्यांनी. So, I think since I'm now beyond Mumbai and Allahabad and in the Supreme Court, I need not have that sense of fear. But I do know that together with this affection which you are doling out for me today, your single-minded affection, there's a world of expectation also. So when I received this recognition, the reference to my judgments, the flowers, the mementos, and the warm words which have been spoken before me by all of you, including my very senior colleague Justice Gawai, the Chief Justice, Justice Gangapurwala, all the members of the Bar Council, I know that that has engendered expectations that something should change. And when we have expectations that something should change, that postulates that something is wrong in our system. And I think as young lawyers who are attending this training program, we need to ask ourselves, what is wrong with our system? We need not cover up the crevices in our system. Because if we try and cover up those crevices, there's a grave danger that, like a trek in the Himalayas, you can fall deep into the crevice without noticing that there was a crevice. So it is important for us to understand what are the problems which beset our system. But before I do so, let me at the outset compliment the Bar Council of Maharashtra on the civil and criminal handbooks which have been released. This is truly a unique venture, the first of its kind in the country. And this could not have been possible but for the dedication which has been shown by those who conceived of it. There's been a reference to Mr. Jai Bhave's vision in conceiving of it. In the mentorship which was provided by Justice Gawai and by Justice Oak, by all those who drafted it, amidst the pressures of their own work, people who felt that they are not only confined to doing their own work, who want to give back to society by preparing these criminal and civil handbooks. It was with the same purpose that when I took over, this was a mission which I had developed for myself almost 6 years back, and for the last 6 years I was trying to tell the Supreme Court Registry to put out the Supreme Court reports in the electronic form. Because my mission is this: how many young lawyers in the country, how many law colleges can afford the cost that you have to pay to an average publisher? You of course have nobly minded publishers like the All India Reporter who have taken up this mission today with a sense of mission and purpose. But how many young lawyers can afford the cost of a law report? And if we do not have access to law reports in preparing for moot courts in the law colleges, or if our young lawyers cannot have access to the judgments of the Supreme Court free of charge, then what are we here for? So the e-SCR is something which I will request all of you to use. It is available in the website of the Supreme Court. It is available for free in the website of the e-committee of the Supreme Court. It is available in the Justice Mobile app as well. And our mission is not just to provide a reporter, but to give you a search facility. So there is an elastic search facility which would enable you to search all the 34,000 judgments of the Supreme Court. But we are not resting there. Yesterday I had a team from the IIT Madras, Professor Mitesh Khapra and Dr. Vikram Raghavan, who has done a lot of work on artificial intelligence. And the next step of our mission is to provide translated copies of the judgments of the Supreme Court in every Indian language. Because it's good that I can reach out to all of you young lawyers who would otherwise, some of you who would not be able to afford the cost of a private reporter. But what good is it to a rural litigant who does not understand the tenor or language or the niceties of English? So unless we reach out to our citizens in a language which they can understand, in a manner which they can comprehend, the work which we do is not reaching out to 99% of our population. And therefore, I do believe that technology, there's always a certain degree of criticism when you adopt technology. There is a technological divide. Will people who do not have access to technology be left out? But my mission for the use of technology is that technology must reach out to those who do not have access, and not to therefore create further barriers to access through technology. So I begin by complimenting the Bar Council, and I'm sure that together we can adopt so many more initiatives, and I would invite all the young lawyers to just surf the e-SCR website and you will find a wealth of information. Justice Gawai is here, Justice Bhosle is in the audience, and I'm speaking to you this evening. All of us had similar beginnings in the legal profession. And this evening I can't but remind myself of the days when we began our practice together. Very little work in hand, little understanding of the law, but we learned at the feet of lawyers whom we followed, the mentors who taught us the elements of legal procedure and legal substance. A very interesting case came to me one day. We are in Dadar. There were a number of hawkers in Dadar and Navi Mumbai. I appeared for those hawkers. Issue was a very interesting issue under Article 19(1)(g) of the Constitution and the Municipal Act. We succeeded. At the end of the day, the advocate who had brought the brief to me came to me and gave me a blank check. There were so many hawkers who had contributed to the cause that the advocate who had given me the brief was so confident that whatever I charge will be less than what he has made in the matter. So he gave me a blank check and said, fill up the check with whatever you want to fill up, and that will be your fee for this matter. This probably took place sometime in 1993 or 1994, 6 or 7 years before I became a judge of the Bombay High Court. And every few months he would come back to me and say, I don't find that you have filled up the check. After 6 months were over, he kept on telling me, you haven't filled up the check. I don't know whether he realized that the check is already outdated, but he never gave me a replacement. On the eve of my elevation as a judge of the High Court, he came to my chamber and to congratulate me. I had that check in my drawer and I said, I'm returning that check back to you, which you had given me. It's blank and it's unsigned. It's blank and not filled up. So in the course of that brief meeting, he said, but why did you never fill it up? This was 8 years back and you could have also done with a hefty fee. So I looked at him and said, it was a temptation to fill it up. But I told him that I didn't fill it up because when I went home that night, I said to myself, if all that I had to achieve by joining this profession was to earn money, I would have rather set up a departmental store and made it in a week of work. And the reason why I didn't set up a departmental store and chose this profession is because there are certain higher values that we pursue when we become lawyers, which we should never leave sight of. So I had my own small rules when I was a young lawyer, and even later. I never charged teachers because I believe I owe everything to teachers. I never charged a disabled person. I never charged a legal professional or any other professional. So I had my own categories. But lest you feel that I was extremely good-hearted, I must also tell you that I had a very realistic experience, which was that whenever I foregoed charging a teacher, a disabled person or professional, in a few days, I would get back a client who would pay me much more than I would have ever imagined in the matter. So, Destiny has a very peculiar way of working itself out. And destiny, in that sense, takes notice of the work which we do. Which really leads me to the point, what is the purpose of our profession? Why are we here? Why are all of you here? I'm delighted to see the number of women lawyers today in this audience. When I joined the profession, the legal profession was also open to women. That was the prevailing logic, that this was a profession where women could also join. Looking at you today, I'm trying to figure out where are the men in the audience. But this is a sign of the times. Maharashtra is a developed state, but this is the movement which is taking place all over the country. When I sit with my colleagues, whether it is in the state of Rajasthan or it is the state of Uttar Pradesh and of course Maharashtra, when recruitment is made to the judicial service, you find that the number of women who are entering the judicial service is now 60% of the new recruits are women, or even more. So this is the sign that women's education is reaching out today. And it has crossed those threshold barriers which women had to experience. Now the challenge before us is, how do we convert this initial period of promise into an age of realization? How do we ensure that so many of these young women lawyers who join us today do not fall by the wayside by so much which confronts them after they join the legal profession? All of you are young lawyers. I interact a lot with young lawyers. The legal profession even today has many feudal remnants. The first is the monetary barrier. Most state bar councils charge extraordinarily high enrollment fees. Maharashtra charges about 15,000 rupees. And I was told, of course, this may not appear to be unusually high. I was just talking to the chairperson. The chairman told me that, well, of course, this also covers very valuable other activities such as insurance. We provide training, we provide materials, which is a valid point, absolutely a valid point. I'm not at all joining issue with that. But I do believe that the state bar councils have to take a relook at the enrollment fees which we charge. Because I have five judicial clerks who are working with me today. Last year, 4 of them were women. There was one male judicial clerk. Now I have 5. None of them is connected with the law. All of them are first generation lawyers. Some of them come from very rural backgrounds. Their ambition, their mission, their zeal to succeed in life has made them reach to where they have reached, to clerk with a judge of the Supreme Court. But all of them tell me of the hardship which they face in terms of trying to meet something as elementary as the enrollment fees. How do we make the profession more democratic? There is an equal opportunity barrier. Apart from the monetary barrier in our profession, there is an equal opportunity barrier. Our mode of recruitment of lawyers in our chambers is not transparent. Opportunities are either closed or are available to selective segments of society. For instance, law clerks who are recruited by judges, law interns who are recruited by judges. I'll talk about my side, so the lawyers don't feel I'm criticizing them. It's better to laugh at yourself than laugh at others. The law clerks, the law interns who are recruited are generally recruited on the basis of an informal network. But how do we then open up this informal network to people who don't have access to informal networks? I'll give you just one example. I have started a process in my own chambers of recruiting law clerks. I have a 3-stage process. We invite applications from all law colleges, not just the national law schools. More on that later. After we invite applications, we first scrutinize the applications on the basis of the biodata, the curriculum vitae, and we give them a simple brief to prepare from a judgment. And we give them a day's time to prepare a brief. We also give them a research note to prepare at home. Sit down and prepare it over a day. That is the second stage. And the third stage is when we do the shortlisting. And then I hold interviews. I have about, say, 25 candidates for interview, and I'll select my 4 or 5 on the basis of that interview. We pay 65,000 rupees a month to our law clerks in the Supreme Court. There is a feeling that, well, should you be paying these youngsters because they are here to learn? I have a different perception. Unless you recognize the value of the younger generation which joins our chambers, whether as lawyers or as judges, we will not look to the future of the legal profession. We must look upon younger people not as people who have come to learn with a sense of charity towards them, but as people who have a valuable contribution to make in terms of the insight which you give, the ideas which they give. So when I work with my own law clerks in my chambers, we discuss so many different things. I value their work and their opinions. We discuss law and life with them. But it is important that lawyers start paying living wages to juniors at the bar. unless we start paying living wages to the juniors at the bar, this profession will not become a democratized profession. Then this profession will only become a profession primarily for those who can survive without depending upon the incomes which they generate from their seniors. That has to change. Just to give you one example, I'm racing against time. I have a flight to catch, but I have so many thoughts to share. When I was in the Delhi University studying for my law, I had a friend who asked me over a cup of tea, as we all used to as young law students. He says, "Beta, tu karega kya?" So I said, "Wakalat karunga." So he says, "But आमदनी कैसे कमाएगा?" So यही तो सीख रहे हैं, वकालत तो करनी है. He says, "Dekh," he gave me a piece of advice. He says, "Your father is the Chief Justice of India. Please make sure that you get a petrol dealership or a retail outlet of an oil company." Then he said, "You can do your legal profession for the rest of your life, but you will have something solid to fall back upon." I was very young and immature. I didn't realize the importance of what he was saying then, but it's something which has stuck in my mind all these years. Because that reflected the perception of the life of a junior, particularly in North India, and I don't think it's very different in the rest of the country. How do we then create this profession? By providing opportunities to youngsters. And that is something which I believe we have to work upon. We need to induct law graduates from marginalized communities in the chambers of lawyers. Their drive to contribute back to the well-being of society is unparalleled. It was only one Cornelia Sorabji who joined the Allahabad High Court because she was denied entry into the bar in the then state of Bombay. But she was the person who led the movement against Pardanasheen women. And why Cornelia Sorabji? How did Dr. Ambedkar evolve? So unless we create a wellspring of opportunity for the marginalized communities, we will not really have law being used as a socially transformative instrument that the law is intended to be. Now it is important that we cross the meritocracy barrier, just as Gavai mentioned about it a short while ago. There is a perception in the legal profession that there is a divide. Graduates from the best universities, from the national law schools, and elite private universities from the metropolitan towns are the sought after people. This divide is stratifying the legal profession, and valuable opportunities are being denied to young lawyers who do not have access to those universities, who can crack a common law entrance test or a common law aptitude test. Only those people can crack a common law aptitude test who are good in English, who have gone to good schools, people who have had the benefit of access to good education. So that is one of the problems. At every stage in access to our legal profession, we are laying down barriers to entry. We need to enhance access to information and knowledge platforms so that students from law schools that do not provide access to knowledge platforms are benefited. Apart from ESCR, one of the missions of the Supreme Court is to have live streaming. The reason why I feel we must have live streaming, the criticism of my move is when people tell me that, well, lawyers will stand grandstanding. Lawyers will start pretending it's a theater instead of a courtroom. I do not have a cynical attitude towards the legal profession. I do believe that lawyers do have a sense of responsibility. Yes, a few people will begin to do theatrics, but that's all right. They're just few and far between. But the great importance of live streaming court proceedings is the education which will provide to people who have no access to formal education in our law schools. Law schools which are not resourced to have good professors will be able to watch Supreme Court proceedings and say, well, this was the matter which was going on yesterday in the Supreme Court. We have all watched it. Now let us sit down and discuss what happened. This is a matter where anticipatory bail was denied by the High Court. This is the matter where bail has been denied by the trial court and by the High Court, and which the Supreme Court has granted after 3 years of custody. Why is it that bail was denied even in this case? When you discuss live issues which emerge before the court, as I do, you'll realize the extent of injustice that pervades our society. The extent of injustice which pervades our society can be realized only when you come face to face with the smaller issues which confront the lives of citizens. And that is why I said that there is no case which is too small and there is no case which is too big for the Supreme Court. One of the initiatives which I have instituted after I joined the position of the Chief Justice of India was to allow mentioning by juniors in my court every morning. Every morning in the court of the Chief Justice of India, I have between 60 and it has gone up to 110 matters which are listed for mentioning. And usually young juniors come and mention that matter. They take about a minute. Somebody will take 30 seconds, somebody will take 50 seconds, somebody will take 2 minutes. One of my colleagues asked me that, is this not a waste of time for you as a Chief Justice of India to listen to this mentioning for half an hour? So over a cup of tea, I said, look, I've thought over it. At a certain superficial level, it appears to be a waste of time when you can be doing far more constitutional work. I said, please realize the importance of it. By listening to the grievances of 70 young lawyers, many of them with small briefs, you understand the pulse of the nation. In those little grievances, 20,000 people whose homes are being demolished, 5,000 people who are being arrested for some other cause, a young cartoonist who is being harassed because they have put out a cartoon which is critical of the government in that state. You understand where the pulse of the nation, as I said, lies. And that ultimately is the great control which we as judges wield, and that sense of confidence which we give our citizens. That if there is injustice which we locate in any part of the system, there must be that one court officer, and I call myself that court officer, who's willing to suss it out and step in. True enough, 70% of those cases, you may not necessarily give an urgent date, but even if there are 5% cases where a citizen is deeply in distress, it is our duty to attend to those issues. I want to conclude by telling you that, remember one thing, the system always lies above the individual. Never regard yourself as somehow above the system. Unless you understand that the system lies above you, there's a great temptation in the legal profession to cut corners and to obtain reliefs at the cost of justice. The cause of justice lies far above the cause of your immediate client in a case. Of course, each of you has to do the best for your client. But while doing the best for your client, you must always realize at the back of the mind that there is a higher sense of responsibility which must guide your endeavors. So I'll leave you at this point. As I said, I could have spoken to you for much longer. I really didn't know when to begin or where to begin. I was so tongue-tied at this huge audience and this wonderful reception which you gave me. But then I came to reality when I realized what wonderful work has been done in terms of circulating the civil and the criminal handbooks. So as I conclude, what can I wish for all of you as youngsters? I'll wish for you that you fly high. I wish for you that you realize your dreams. And then I thought I'll wish for you, in the words of Iqbal, in a little couplet. I don't think I can match Miss Wagmare with the couplets which she has been coming out with this whole afternoon. But I'll try and just say one, a couplet by Iqbal. And the couplet is, for the young lawyers. सितारों के आगे जहां और भी है, सितारों के आगे जहां और भी है, अभी इश्क के इम्तिहान और भी है. सितारों के आगे जहां और भी है, अभी इश्क के इम्तिहान और भी है. तू शाही है, परवाज है, काम तेरा, तेरे सामने आसमान और भी है. So I thank you very much for this warm felicitation. Namaste and God bless.